Hello, Hector Quiroga with the Quiroga Law Office. Today I'd like to talk to you about gym liability or gym owner liability. Some people like to work out, and when they go to the gym, the question is, if they get injured, what liability does the gym owner has, or the management? What duties do they have to follow to ensure that their clients, their customers, are safe? Okay. Well, this is kind of a twofold question. One is typically smart gym owners will have a liability waiver or a disclaimer on which you would waive any claim against the gym owner for any injury that happens during a workout. Okay, so the first question is: are these waivers of liability, are they enforceable? Number one, the waiver has to be done very carefully, very well drafted. It can't just be a form that is sort of downloaded out of the internet. It can be a form downloaded on the internet, but if it's not specifically applicable to the state of Washington or local laws, a good lawyer may be able to set it aside. Without that waiver, the gym owner is pretty liable on anything that happens, because they have to protect the consumer from any foreseeable harm. And anybody who's straining too much on a workout is foreseeable that they may get injured, that may get strained, or they might pull their back, or whatever may be the case. So this waiver is sort of the gatekeeper in many ways between the gym owner, the gym management, and their customers. Now, there are other requirements for the waiver, of course. The person who signs it has to have capacity, not just age, 18 or over, but they have to have capacity to sign, which most people do. And one of the things that typically challenges a waiver is this appreciation of the risk. Can we appreciate how I'm going to be injured? And I think in a reasonable way, most of us can say, look, if you go to the gym and you're working out and you're pushing and pushing and pushing, at some point certain injury is going to happen. If you're pushing your boundaries to outside the reasonable or the healthy standards, you're going to hurt yourself. And we can almost see that happening, where you're pulling and maybe a muscle gets pulled or something like that. And that's something I think that we can all appreciate. So what risk we cannot appreciate, which would probably not be waivable? Okay, one risk that is not appreciable. I guess before I go to that, let's talk about the other opposite risk that we just could never see. Let's say is let's talk about is an attack. Okay, some sort of sexual harassment issue where a male customer attacks a female customer because she has tight pants, okay, and that type of thing. Okay, well, that's really outside of the waiver. The question is going to be, did the gym owner know about this situation? Did they took any steps, or did they not know at all? It was completely random. It was just criminal activity, or it was just harassment that happened over and over, and the gym owner failed to provide any safeguards for this type of thing. So that's the other extreme, where I think we're like, boy, that's outside of the appreciation of the risk. So where then does the dispute begin? Is kind of like in the middle of the road, when we have those cases where somebody the machine malfunctions and hurts somebody. You're working, maybe the individual is working too hard, starting to push those healthy boundaries, and the machine fails, and it just pulls back, or it does something to injure you. Okay. Now, is that something that we can appreciate? And I'm inclined to say no. Malfunction of the equipment is something that you don't really waive. You don't say, if the equipment malfunctions, I'll take all personal, I will not hold you liable. Again, if I work out and I overdo it and I get hurt, I can see that. But malfunctioning of the equipment, that's one thing. What about misuse of the equipment? What about when somebody is working out in a way that the equipment is really not meant to do, or meant to be using those terms? Can that person then later go back against the gym owner? The question is maybe. Why maybe? Because if the gym owner takes a lot of time explaining that they are going to provide, say, classes, or they're going to have people helping with other things, showing you how the equipment works, all of this stuff, then maybe it's past that waiver point. So again, for a gym owner, they would have to have a very solid waiver, make sure that it works, but that doesn't totally disclaim 100% of any duty to their clients. They have to still provide a safe workout environment, because that's what they're being hired to do. That's what you pay a gym to do, is to provide a safe environment. Does that mean that you can go against the gym owner at any minute? No, you gotta get past the waiver. Now, if there's no waiver because there's a paperwork issue or somebody didn't ask you to sign it, then obviously that's a whole different thing. But there is liability there. There could be liability there, I suppose. Can be blocked or can be defended. That's the question of the waiver. My name is Hector Quiroga. I'm with Quiroga Law Office, and if you have any questions, please leave us a comment or call me at 509-927-3840. Thank you.